All right, Ms. Abraham, do we know who we have ready in the jail?
And we have Angel Long ready for her plea with Miss Beasley.
All right, Ms. Long and Ms. Beasley will step up. Good afternoon, Ms. Beasley.
Good afternoon, Your Honor.
All right, Ms. Long, if you'll raise your right hand, I'm going to place you under oath. Ma'am, do you swear the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you put your hand down. Ms. Long, make sure that you speak up loudly and clearly today. I have a court reporter here with me, and she has to take down everything that we say, okay?
Hi, Judge.
You have to say yes or no, okay?
Yes, sir.
If I'm not conducting your hearing right now, please stay muted. So, Ms. Long, is your name Angel Lee Long?
Yes.
And Ms. Long, are you a United States citizen?
Yes.
And do you read, write, and speak English?
Yes.
And in this case, you're represented by your attorney, Miss Debbie Beasley. Are you pleased with her representation of you?
Oh, yes, sir.
You feel like you've had enough time to discuss your case with her and have all of your legal questions answered?
Yes, sir.
Is there anything about the paperwork that you have read and signed that you do not understand?
No, sir.
And your signature as it appears throughout this paperwork, is this your true and correct signature? And I'm going to show you. Is that your true and correct signature there?
Yes, sir.
Okay, thank you. All right, and Ms. Long, have you ever been diagnosed with any type of mental conditions?
No, sir.
All right, Ms. Beasley, do you believe your client to be competent today?
Yes, Your Honor.
And you've explained to her her legal and constitutional rights?
I did, Your Honor.
All right, this appears to be a motion to revoke, and the plea agreement appears to be that Ms. Long is going to plead true to the violations alleged in the state's motion to revoke in exchange for a recommendation of 12 months confinement in the state jail division of TDC, balance of her financial obligation, with the state agreeing to waive count 1 on the state's motion to revoke. That's okay. And it looks like she will also be entitled to 365 days credit towards her sentence in this case. Is that your understanding, Ms. Beasley?
Yes, Your Honor.
All right. All right, Ms. Long, you appeared before the court in October 16th of 2018. You pled guilty to the state jail felony offense of unauthorized use of a vehicle. The court heard the evidence that day, found that there was sufficient evidence to convict you. The court did convict you, assess your punishment at 2 years confinement in TDC. However, the court suspended the sentence on that date and placed you on community supervision for 5 years. It was during that period that the state has filed its motion to revoke your community supervision, alleging 4 counts. Have you had a chance to read over this motion to revoke with your attorney, Ms. Beasley?
Yes, sir.
Ms. Beasley, does your client waive the formal reading of the state's motion?
Yes, Your Honor.
All right, with the court's understanding that the state is going to waive and abandon count 1, then I would ask you at this time, Ms. Long, how do you plead to counts 2, 3, and 4 as contained in the motion? Are those counts true or not true?
True.
And Ms. Long, are you telling me that those counts are true because those counts are true and for no other reason?
Yes, sir.
And Ms. Long, has anyone threatened you or forced you or made you otherwise feel like you must plead true to any of these counts?
No, sir.
All right, the court will accept the defendant's plea of true. Ms. Beasley, is there any objection to State's Exhibit A, the defendant's waiver of rights and plea of true?
No, Your Honor.
All right, State's Exhibit A is admitted into evidence. The court takes judicial notice of Ms. Long's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense?
No, Your Honor.
All right, based on the evidence presented to the court, I find that Ms. Long has violated the conditions of her community supervision. The court hereby revokes her community supervision, assesses her punishment in compliance with the plea agreement at 12 months confinement in the State Jail Division of TDC. Court will order her to pay the balance of her financial obligation. Court finds counts 2, 3, and 4 to be true. Court awards Ms. Long 365 days credit towards her sentence for time served in this cause.
And Your Honor, if I may, there is a second case endangering a child that Ms. Curry has agreed not to pursue based on this plea.
And that's correct, Your Honor. That case has already been declined by our office.
Okay. Ms. Long, looks like you're going to be getting out of jail today, and it looks like you still owe quite a bit of restitution to your victim. Actually, it looks like you owe Van Zandt County over $3,500 for health care that you received through indigent health care, in addition to a fine and a court cost. I'm assuming that there's going to be new attorney fees as well. So Ms. Long, when you are released from the jail, I'm going to order you to report to the Van Zandt County Courthouse so you can meet with the court's compliance officer so you can make arrangements to discharge the money that you owe. Your failure to do so will result in the court issuing a warrant for your arrest. You understand that?
Yes, sir.
It's important that you pay off what you owe and hold up your end of the plea agreement. You understand?
Yes, sir.
All
Well,
right.
my understanding, she has all of her back time credit, but there is a high probability that the state jail system will want to ship her down and process her at the state jail.
Okay, I can't speak to that. So whenever you do have that opportunity, I want you to report to the courthouse and make contact with our court compliance officer, okay? All right, I find that you've already been fingerprinted on the judgment. So at this time, Ms. Long, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of your sentence. Good luck to you, ma'am. And Ms. Beasley, I'm gonna need, or state, I'm gonna need some type of paperwork to support the billing on that rejected endangering. It's on this bill. So I'm gonna need a rejection letter or something to accompany this so that I can support it in case I'm audited by the state.
Judge, I'll email the disposition to Ms. Patty.
Thank you. And so, Ms. Beasley, I'm gonna mark out this additional $150 here, and I'm gonna move it up to rejection so that it matches, because there's nothing in this judgment that says that a misdemeanor was $1245. Okay, so I'm gonna make that change. It's not gonna change the amount of your bill at all. It's just gonna make it correct.
That's fine, Judge.
All right, I just want to let you know.
Okay.
Beasley, do you have any other inmates ready or any other clients today?
Yes, sir. I have Donald Ellis on the docket.
All right, if Mr. Ellis is available, if he'll step on up. All right, CR 19-305, State versus Donald Brian Ellis, set for pretrial.
Yes, sir.
Do you have any pretrial issues, Ms. Beasley?
Yes, sir. I've been in discussions with Ms. Curry. We received a plea offer late last week. That plea offer is 16 years TDC time if we do the plea by April the 1st. In addition, we had discussions after that. My client is requesting that an additional new DNA test be conducted to compare the male DNA that was found during the same exam to his personal DNA. Ms. Curry says that if he waits to have the new DNA test done, then the offer will be nothing less than 25 years TBC. So Ms. Curry and I have had phone call with the lab to determine if there's enough DNA sample to be compared to my client, and we don't have that answer yet. So we're waiting to find out if it can be compared, and we're trying to find that out as soon as possible.
If there is sufficient sample for the additional testing, what's the plans on that testing? Is it going to be conducted by the state laboratory or independent laboratory?
That's something that Ms. Curry and I will have to discuss. We haven't discussed that yet. Probably independent.
So Ms. Curry has made the acceptance of the plea bargain conditional on April 1st. That's next week. The only setting I have between now and then is the evidentiary hearing on the 30th. Do you have an anticipated response from the lab? Response date?
Not yet, Your Honor. We're working on that. I plan on being here next week to talk to my client, obviously to try to get that information for him so that if he accepts this 16 years TBC, we can get that done before April the 1st.
Before next week?
By the end of next week. I think April the 1st is on that Thursday. I'm doing everything I can to get that information so he can make an informed decision.
Okay, well, let's just go ahead and set him then for April 1st and we'll get an update if you have additional information or you don't. So we'll set for an additional pretrial on April 1st at 1:30. I appreciate the update, Ms. Beasley.
Okay. Thank you, Your Honor. May I be excused as well as my client?
Yes, ma'am.
Okay, Judge, we have Jonathan Manning's writ on Caleb Richardson, and they're in the courtroom.
Do we have, that might take some testimony and some time. Do we have anyone else that's ready?
We have Casey Ashmore. We have Mr. Howard for Casey.
All right, let's go ahead and bring in his client.
Bring up Mr. Ashmore's.
Yes. All right, this is cause numbers CR 20-215, 252, 253, 254, and 343, State versus Raymond Bernard Howard. And I show that we are set for docket call on all of these cases.
Yes, Judge.
Also have a note that there's been a letter of representation e-filed with Mr. Adrian Crane expecting to file a motion to substitute. Do we have any additional information on that?
Yes, Judge. The notice of appearance that Mr. Crane filed was followed up with an email to Ms. Tabram and our office that he had not been financially retained and was not going to engage our client. So in response to that, and out of an abundance of caution, we've filed some additional motions that we think are prudent just to be able to go forward. We're going to ask the court to set those on an evidentiary, probably along with Mr. Crane's motion to withdraw, which he said he would be filing.
All right, give me a moment to, has Mr. Crane, he's filed a letter of representation. Has he filed that with the court? I don't see that. And here, maybe I do. Look here. Let me look here. Just a second.
Also, I apologize, Judge. I thought you were greeting me, so I was greeting you back. I didn't mean to interrupt your proceedings.
That's okay.
Judge, if memory serves, in February or early March, right around the ice storm, Mr. Crane filed what I believe is a notice of appearance and a motion requesting a bond reduction.
Yes, I'm viewing that. That was February 12th. Mr. Crane, is Mr. Crane not with us today?
Judge, his communication with our office was that he would not be representing Mr. Howard and had no plans for future appearances.
Well, how convenient for him. So he files a letter of rep and then doesn't appear in court at the next hearing.
And he did not respond back to my email that I had sent him about the motion to substitute.
So the court has not recognized him as counsel because there is no order substituting counsel. Am I correct on that, Mr. Ashmore?
That's correct, Your Honor.
And Judge, our communication from Mr. Crane says that he would be happy to file a motion to withdraw if the court needs him to do that. But if he's never been the attorney of record, then I'm not sure that that would be necessary.
All right, Mr. Ashmore, I'm reviewing your motion to disclose informers. Is that the motion you're talking about?
Correct, Judge. There's two of them.
Is it just an omnibus motion?
Yeah, it's just an omnibus, and I know that there's Van Zandt County standing order, but we've tried to make sure that this dovetails and augments as opposed to refiles in contravention of what that standing order asks us specifically not to do.
In your omnibus, what is being requested that's not covered by the court standing order?
A lot of this is at the specific request of Mr. Howard, who's had the opportunity to go over his discovery multiple times and has affirmatively asserted that his rights need to be better asserted to the court.
Understand, but what in the omnibus motion is being requested that's not covered by the standing order?
Yeah, Judge, this is a situation where we've represented to the court before. We don't believe anything, but Mr. Howard has made it very clear to me and our firm that he doesn't believe the standing order is sufficient under 3914 to protect his rights.
Okay, but that puts me in a position that I have to know what's being requested. I mean, how do I conduct a hearing on this omnibus motion if I don't know what's being requested that's not already been ordered by the standing order? So I need to know specifically what is it that I'm supposed to review and either grant or deny that's not already been ordered by the standing motion or by the standing order.
Right, and then really the only thing we're trying to make sure we've specifically asked for is that whether there is any informant, right, or any informants, whether there's any extraneous offenses that we don't yet know about, what they are specifically and how they're going to affect a punishment, and anything else that the state may have under 3914, even though we believe the state has flipped over the rocks and we've looked at them all. Again, just trying to make sure that Mr. Howard's rights are properly asserted to the court.
And state, have you reviewed his omnibus pretrial motion?
Judge, Mr. Ashmore informed me that it would be filed. I don't believe that it is passed through the clerk's office to us, or maybe Ms. Curry has received it, but I have not seen a copy of it yet.
It's on file with the clerk.
I think that just happened, Your Honor, if I could
Yeah,
answer
it was
that.
yesterday afternoon about 3 o'clock.
Yeah, and we're not trying to prejudice. I did send an email to the state. Again, give them the heads up that this was coming, and
Okay, so you're asking for an evidentiary hearing on your motion to disclose informers?
Yes, Judge. What would the court have available on that?
Next Tuesday. You available on that day, Mr. Ashmore?
I am, Your Honor.
All right, so the court will set Mr. Howard then for the evidentiary docket next week, Tuesday, 9 a.m. on the motion to disclose informants. We're also going to set it for docket call that same day. So the court will dispose of the pretrial motions that date, and then we'll also take Mr. Howard's request for either a jury trial, bench trial, or plea agreement up on that same day.
I really appreciate that, Your Honor.
Anything further, Mr. Ashmore, on Mr. Howard's behalf?
No, thank you again. I'm sorry I couldn't be there in person today. I appreciate the court working with us on our scheduling issues.
Is he the only one that you have this afternoon?
He is, Your Honor.
All right, Mr. Howard, we'll see you back next Tuesday at 9 a.m.
Yes, sir.
May I be excused, Your Honor?
Yes, thank you, Mr. Ashmore.
Thank you so much, sir.
You're welcome.
We have Jonathan's, and then we'll take these 4 back or 3 back and get the 3 others.
Okay.
And Judge,
All right.
before we begin this hearing, I just wanted to make the court aware. I see Ms. Tabraham at the jail. I sent her and Mr. Manning state's proposed one for this hearing, but seeing that she's at the jail, I'm not sure if she's gotten that. What's the best way for me to get that to the court?
I don't know. I can't access email on the bench and print and do all those things. So I don't know. What is
I think we'll provide a solution. We're going to object to that irrelevant. It's not relevant to this hearing. And so we're going to go ahead and object to that piece of evidence being submitted.
I have no clue what it is.
Judge, it's the probable cause affidavit from the arrest. I believe it's highly relevant as to the nature of the offense in considering what potential bond should be set at.
Mr. Manning, do you have access to it? Have you been provided?
When she just mentioned it, I was able to pull it up and see that it was a PC affidavit. I haven't reviewed it yet. But Judge,
Hang on. Before we do that, we're just talking logistics here. So you do have access to it?
on my phone, yes, sir.
Okay. So I guess Ms. Heisel, I'll just allow you to share screen and you can show it to me that way. And then we can pull it down and save it later for Ms. Grisham as the keeper of exhibits.
Sure. And it's already been sent to Ms. Tabraham, and also Ms. Barker said I could send it to her, and one of them can get it to Ms. Grisham.
Or Ms. Burton said you can send it to her and she's in the courtroom.
Okay.
She's in the
All
jail
right.
courtroom.
Okay. All right. So let's go ahead and call this case. This is writ number WR 21-19, State versus Caleb Richardson. And is this a writ seeking bail reduction or probable cause?
Judge, this is a 17-151 delay hearing.
Okay. All right. Are you calling any witnesses today, Mr. Manning?
Judge, I will be calling my witness, or my client as a witness shortly.
All right. I'm going to go ahead and swear in. Mr. Richardson, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. You may put your hand down. Go ahead, Mr. Manning.
Judge, before we begin, I'd ask the court to take judicial notice of the court's record, specifically the affidavit in order of indigency. Also, I'd ask the court to take notice of the record that there has not been an indictment filed in this case as of yet. May I proceed?
Well, I don't know that I can. So Mr. Mr. Richardson has not been indicted, so there is no clerk's record. And so I do not have access to the affidavit of indigency. I don't have that. I haven't seen it. Ms. Taberham, my staff would have that, but she's at the court with you, so I won't be able to review that today.
Okay.
Unless you have it and you can share it.
I don't have a way to share it right here with me, but I can provide that if court would need that for further review in making their decision.
Ms. Heisel, do you have any objections to the court taking judicial notice of the affidavit of indigency?
No, Your Honor.
All right, so the court will take, and Ms. Heisel, do you stipulate that Mr. Richardson has not been indicted?
That's correct, Your Honor.
Okay, so the court will take judicial notice of Mr. Richardson's affidavit of indigency, and the court will find that Mr. Richardson has not been indicted as of this date. Go ahead, Mr. May.
May I call the client?
You may.
Mr. Richardson, when were you placed in custody?
It was around December 9th.
You're going to have to speak up. If I can't hear you, you can't get relief.
December 9th of last year, sir,
Okay.
And what was your bond set at that time?
at $100,000.
Okay. And have you been in continuous custody here in the Van Zandt County Jail since December 9th of 2020?
Yes, sir.
And are you able to make any bond payments?
I have $500 to my name that I can use to bond out, but outside of that, no, sir.
Okay. And do you have access to that $500 in your current state being here in the Van Zandt County Jail?
No, sir.
Okay. And do you have anyone on the outside that can access that for you in order for you to have funds for a bond?
My mother, she's 2.5 hours away, but yes, sir, my mother.
And beyond that, do you have any property that you can use to make bail?
I own no property.
And do you have any money saved up or access to any money that friends or family have?
Other than the 500 that I have for my mother. No, sir.
Your Honor, I pass the witness.
State, any questions for Mr. Richardson?
Yes, Your Honor. Mr. Richardson, if you were to make bail in this case, where would you be living?
My grandparents have land in Wills Point, and I'll be staying with them to help take care of their land.
Okay. And I'm sorry, I believe your attorney asked you this question, but do you have a vehicle?
No, ma'am.
Okay. How would you get to court if you were to make bail?
My grandmother.
Your Honor, I'd pass the witness.
Mr. Manning, any additional questions?
No questions, Judge. Just a brief argument.
Any evidence from the state?
Yes, Your Honor. The state would offer proposed exhibit states 1, which I can share for the screen, assuming the court is going to rule on Mr. Manning's objection.
Do you maintain your objection to State's Exhibit 1?
Yes, Judge, under Gill and 17.1, it's not relevant to proceeding. What's relevant to proceedings, Judge, is that he has been detained by the state. The state's not ready to proceed a trial. It's been past 90 days. Those are the only things that are relevant. And what the offense is, what considerations for safety of the victim or anything else are not relevant under Gill for this hearing.
And what is Mr. Richardson charged with?
Aggravated assault with a deadly weapon, Your Honor.
All right, the court's going to overrule the objection, and court will admit State's Exhibit 1. And you said that's the PC affidavit for the arrest?
That's correct, Your Honor.
All right, if you want to publish at this time.
And Judge, if you'll just let me know if everyone can see that. I don't know what you can see.
Yeah, I can see it. Bye.
And Judge, would you like me to read the PC affidavit for the benefit of everybody or just publish it via Zoom?
Just publish it via Zoom, that's fine. Give me a moment to review it. Are you going to ask Mr. Richardson questions after our review?
No, Your Honor.
Okay. If you could scroll down a little bit, Ms. Heisel, I don't think I can control it. Okay, if you could go down a little further.
I believe that's the end of the affidavit, Your Honor.
Okay, you're right there. Okay, thank you, Ms. Heisel.
Your Honor, the state would rest.
All right, closing arguments, Mr. Manning, go ahead.
Yes, Judge. As I mentioned before, we've proven up that Mr. Richardson has been detained over 90 days since December 9th, 2020. The bond that was set at $100,000. The state's not ready at this point in time. And so, as I said, under 17151, under Roe and its progeny, as well as under Gill, the court needs to make a decision as to a bond that he can make or a PR bond in this situation.
State.
And Your Honor, just for the court's record, we do have this case in our office and we do intend to indict it at the next grand jury setting. However, I do understand that we did not get that indicted at the 90-day mark and that under the law, Mr. Richardson is entitled to a bond reduction. In fact, the state has offered Mr. Richardson a bond reduction to $50,000, which is half of his current set bond. We believe that is still a reasonable bond, given the violent nature of the offense and the facts and circumstances laid out in the PC affidavit. Your Honor, we would oppose a PR bond for the safety of the community and any reduction below $50,000.
Your response, Judge?
Yes, sir.
Judge, it doesn't matter what bond is offered by the state. What matters is what bond my client can make. And Judge, you heard testimony that my client only has $500 to his name. He's unable to access those funds from the jail. Furthermore, he has no family, friends, or relatives that can provide him the ability to make a bond of any amount at this point in time, nor does he have any property that he could use to make a bond. So for these reasons, we'd be asking for a PR bond.
All right, thank you, Mr. Manning. All right, the court will take this under advisement and will issue a written order at the end of the hearing today, at the end of the first docket today.
I believe that concludes my business. Might be excused.
Yes, thank you, Mr. Manning.
Thank you, Your Honor.
You're welcome. Ms. Abraham, who do we have next?
We have Mitch Adams and Crystal Barnes.
Okay. CR 2102, State versus Crystal Lynn Barnes, set for pretrial today, Mr. Adams.
Good afternoon, Your Honor. On Ms. Barnes' behalf, I don't have any pretrial issues to bring up at this time. I received or was informed of a plea offer by the state earlier today. However, this is a third-degree felony, and the plea offer of 12 months doesn't make sense to me, or maybe I misunderstood. So what I'd like to do is request a reset from Ms. Barnes so that I can clear that matter with the DA's office and hopefully conclude our plea negotiations so that we know what the bottom line insofar as the plea offers is. Ms. Barnes has asked me to request the court to allow her to urge her pro se motion for a PR bond.
All right, the court's going to deny that request. And the court will set Ms. Barnes for a docket call on.
That's not what I asked, Your Honor. I'm sorry. I'm not trying to be disrespectful or rude. I just asked for a bond reduction, please. I have family that's in.
No, listen. I've denied that. That's exactly what Mr. Adams said.
Oh, I thought he said for a PR bond. I just wanted a bond reduction, please. I have family that's dying in the hospital. And I have a broken-
Miss Adam or Miss Barnes, I've said no. I've said I've denied it. So you can't just keep on talking to tell me what you want to tell me. All right? If Mr. Adams files a motion for bond reduction, then that'll be before the court. He's your court-appointed attorney that you requested. And so now you need to work through him.
I've asked him very nicely to do it for me.
I understand.
He's just not been very nice to me. And my family's dying in the hospital and and I've got a broken finger I need medical help for, and he won't listen to anything I've asked. I was just like, please.
I understand. Court's going to set Ms. Barnes for docket call on April 27th.
1:30, Your Honor.
Yes. 9 a.m. if she makes bail.
Yes, sir.
May I ask for a different attorney, please? Please.
You can do so in writing. You can file a,
I've already done that in writing once before. Please.
do it again. Do it again. We're not going to do it today.
Okay. Thank you.
So submit it in writing to my coordinator, Ms. Patty Tabraham. And then if the court finds that it's something the court wants to entertain, then I'll set it for hearing and bring both of you back and give each one of you an equal opportunity to be heard.
And what do I do if my family member dies while I'm in here? Because they're in Baylor Hospital and they're dying from corona and pneumonia.
So you want me to tell you what you should do if your family member dies while you are locked up on a 3rd-degree felony?
Yes, sir.
I would say you would need to pray for your family and pray for those around your family. What else would I tell you, Ms. Barnes?
Just please, may I have a bond reduction, please?
You expect me to tell you to dig a hole in the wall and escape?
No, for sure not.
Well, don't ask me a ridiculous question like that. Okay? I don't treat you like that. I would appreciate you not treating me like that. All right? This is a law.
I did not mean to be-
This is Ms. Barnes, listen, this is a felony offense. You're looking at up to 10 years in prison. All right? This is not a stealing a pack of gum from Walmart.
I know, and I understand that.
You need to recognize the circumstances that you're in.
I understand that.
We'll see you back on April 27th. You file it in writing with Ms. Tabraham and I'll review it.
Yes, sir. I was not trying to be disrespectful in any way.
I understand. I've got to go on to the next case.
Your Honor, I think that's all the business I have before the court this afternoon. I'll be excused.
Yes, thank you, Mr. Adams.
Thank you, Your Honor.
Ms. Tabraham, do we have anyone that's ready?
Yes, sir. We have Mr. Kronberger, and I believe Mr. Rollins must be standing in for Jeff. But
That's correct, Your Honor. How are you doing this afternoon?
I'm doing fine, Mr. Rollins. How are you doing?
Just fine.
How's that sorry law partner of yours?
Well, he's back in the office, and I don't know who's the most happiest, but I can bet it's me.
Yeah, I bet so. All right.
He's doing good.
Mr. Kronberger. All right. This is CR 20395, CR 2024, State versus Brian Scott Kronberger. We're set for pretrial on the first case, arraignment on the possession case. Do you know if Mr. Kronberger has been presented with the indictment, Mr. Rollins?
I don't know the answer to that question, Judge.
All right, let's just go ahead and we'll arraign him real quick. Give me a second. I'll pull up his case. Mr. Kronberger, can you see this document?
Yes, sir.
All right, let the record reflect that the court is having displayed online the indictment in CR 21-24, charging Mr. Brian Scott Kronberger with a violation of Health and Safety Code 481.115 subsection D, possession of controlled substance in penalty group 1, greater than or equal to 4 grams, but less than 200 grams. Mr. Kronberger, I'm going to ask you to take just a moment to read, and when you get down to enhancement paragraph 2, let me know and I'll move it down further.
Okay.
Just read to yourself silently, and I'm assuming you read, write, and speak English?
I do.
Okay, go ahead.
Okay. Okay.
All right, Mr. Kronberger, do you understand what you have been charged with in the state's primary paragraph in the indictment?
Yes, sir.
Is your name spelled correctly here in this document?
It is.
Right, and do you understand that the state has also alleged enhancement paragraphs alleging that you've been convicted of offenses prior to the primary offense?
Yes, sir.
And Mr. Kronberger, do you waive the formal reading of this on the record?
Yes, sir.
Okay. Mr. Rawlings, does your client enter a plea of not guilty?
That's correct, Judge.
All right. Court, and Mr. Kronberger, as it stands here in the indictment, the charge of possession of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams is a second-degree felony offense, which carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice. If the court or the fact finder in this case, a jury, finds that the allegations contained in state's enhancement paragraph 1 and 2 are true, then the range of punishment would be increased to what is referred to as habitual felony offender, where a minimum confinement of 25 years to a maximum confinement of life or 99 years. Do you understand the range of punishment for both the second degree felony and also the habitual felony offender?
Yes, sir.
Okay. Court will find that Mr. Kronberger has been formally arraigned today, has waived the formal reading of the indictment in this case, has been presented with the indictment, and has entered his plea of not guilty by counsel. All right, so Mr. Rawlings, do you know if Mr. Wood has any pretrial issues or requesting any contested pretrial motions on the earlier case, the firearm by felon?
Judge, I don't know if he has any contested issues. What my understanding of the overall situation is Mr. Wood had to appear in federal court over in Marshall this afternoon. He asked me to stand in for him. And it's also my understanding that he may have another docket with you sometime late in April. I want to think it's the last week of April. And what he's asking is if we can move this cause number 00395 pre-trial setting over to a docket in April, and then move this new case that we were just discussing to that docket as well.
Okay, my review of CR 2395, I do not see any contested pretrial motions filed, and the deadline to file those would have been 7 days prior to this hearing. So finding that there are no pretrial motions filed, what I can do, Mr. Rawlings, is I will set the first case for docket call, and I'll set the second case for pretrial, so that if there are any contested pretrial issues on the second case, we can take those up. I believe that I'm going to refer back to my morning docket. I believe I set Mr. Wood on another con on April 27th. So what we'll do is on the firearm by felon, we'll set that for docket call on April 27th, and on the possession case, we'll set that for pretrial on April 27th.
Yes, sir. That sounds good to me.
So Mr. Kronberger, if you get out of custody, then your hearing will be at 9 a.m. that morning. If you remain in custody, then the court will have you brought before it in the afternoon. Do you understand?
Yes, sir.
All right. So we'll see you and Mr. Wood back on April 27th. Mr. Rawlings, I appreciate you standing in for Mr. Wood today.
Yes, sir. Thank you, Judge. May I be excused?
Yes, sir.
All right. Have a good day.
You too. Yes, ma'am, I'm ready.
We have Tristan Martin for Ms. Thompson.
All right, this is cause number CR 2180, State versus Tristan Paul Martin, set for pretrial today. And Ms. Thompson, I saw that you had a motion for continuance filed. I expected you to still be in trial today. Did your CPS trial resolve?
Yes, sir. It ended at noon, directly at noon. So I wanted to make an appearance on Mr. Martin's behalf. We do
Okay.
have an agreement on
Go
this case. On the motion for bond reduction, we have an agreement with the state to reduce to $2,500 if the court approves.
Yeah, the
That's
court,
correct.
based on that being an agreed motion, the court will approve that motion and grant the motion to reduce bail to $2,500, and that's cash or surety?
Yes, Your Honor.
Okay.
Surety bond, Your Honor.
And so you're withdrawing your motion for continuance based on your ability to appear today?
That's correct, Your Honor.
All right. Are there any other contested pretrial matters we need to address, Ms. Thompson?
Your Honor, I would ask for a resetting on the pretrial as I have not yet filed the pretrial motions I need to file, and there may be some additional pretrial motions that I'm going to need to file once I consult with Mr. Martin.
My only concern with that is the code says that those had to be filed 7 days prior to today's hearing, and that I could grant that, but there has to be good cause shown as to why they weren't already filed. State, do you have an
Your
objection?
Honor, we have no objection. Ms. Thompson emailed me and told me some potential issues she saw. Did not specifically tell me that there were motions coming, but told me that there were some issues we needed to discuss in this case. So we wouldn't be opposed to a reset to allow us to discuss those issues.
Okay. There being no objection, then the court will set Mr. Martin for pretrial on April 27th. Mr. Martin, if you post bail, then you're due back in court in person on April 27th. Do you understand? This would be the only notice that you get. I'm not filling out a notice and giving it to you and doing all those things. So you understand that it'll be at 9 a.m. on that date. If you don't get out of jail, then the court will come to you at 1:30. You understand?
Yes, sir.
Okay. All right, then the court will sign that order reducing bail, and we'll see you back on April 27th.
Your Honor, if I may interrupt, Mr. Martin, you need to call my office if you get out.
Yes, ma'am.
Thank you.
All right, thank you, Ms. Thompson. Thank you, Mr. Martin.
Your Honor, that's all I have, may be excused.
Yes, ma'am, thank you. I appreciate you being here today.
Yes, sir.
Yes, ma'am.
Okay, is Kyle Steele or Bill Stevens on yet?
Mr. Steele, yes, let me get him.
Okay, we haven't brought his person up. I just want to make sure to go get him or not. Okay, so we will bring up Joshua Martin next.
Okay. Do we have anyone else in the courtroom that's ready?
No, sir.
Okay.
'Cause all we have left are Mr. Steele and Mr. Stevens.
Okay. And it's still a little bit early for Mr. Stevens. He said it may be 3 before he's here. So
Now, he was coming out here in person, right?
I believe so.
Because he has one plea out here.
I believe so. Yes, ma'am. And state, just for your records, the Community Supervision Department and Mr. Steele on James Cody Gray, Mr. Gray's urinalysis was negative. So the court released him and had him report to probation to meet with his officer at his scheduled time, and just to be back in court on that date that I gave him this morning.
1 out of 2 ain't bad, Judge.
Adding 50% gets you a Hall of Fame.
Right. I'd go to the Hall of Fame for that.
That's right. So we'll stand in recess until we get Mr. Martin brought up for you, Mr. Steele.
Yes, sir. Thank you.
Judge, we're ready.
All right, Mr. Martin, come on up. All right, cause number CR 19180, CR 2398, State versus Joshua McMartin, hearing on his motion to revoke and the pretrial on driving while intoxicated third or more. Go ahead, Mr. Steele.
Judge, I've been in contact with the state. They relayed me a new offer yesterday. We've been working on, trying to get something worked out. I don't have any pretrial on the new case at this juncture, and I'm asking for a reset to final pretrial.
Mr. Martin's been in jail for quite some time, I believe, on his motion to revoke. Do you want me to set that sooner?
I'm due back on April 27th. If the court needs to set it sooner, I could probably make that work, but I think we'll have an answer on everything by April 27th, Judge.
Well, let's do this. I'll see your April 27th and I'll raise you two. Set for contested evidentiary on the 29th.
Yes, sir. That's the same day. Gray.
So if there is no resolution, then the court will just take up testimony on the motion to revoke, and then we'll set docket call on the driving while intoxicated on that same day. So regardless, on the 29th, we can resolve one case for sure.
100%.
Okay. All right. So we'll see you back on the 29th, Mr. Martin. And if you and the state work out something before then, Mr. Steele, you'll let me know and we can get you in sooner.
Yes, sir. Thank you, Judge.
All right. You're welcome.
Thanks. Have a good day.
Okay, as soon as you see Bill Stevens, we'll go ahead and bring his men up, his defendants, and then just whenever you have him, we'll get back on.
I think you'll see him before me.
Oh, okay. Oh, yeah, he's coming here. I'll tell you.
But I'll stand by the window and if I see his car go by, I'll send you.
Okay, you signal to me.
I'll send you a bat signal.
Judge, can I get the reset date on Mr. Martin?
Yes, April 29th, we set his motion to revoke on that contested docket date. Mr. Steele had asked for the 27th. And so I told him we would just set it for the contested docket on the 29th, and his DWI in the second case, we set it for docket call. He didn't have any pretrial motions on the 29th as well. So
Thank you, Judge.
we could resolve at least one of them on the 29th for sure.
And I think resolving one will resolve the other either way we go.
May. Okay. All right. So we'll stay in recess and we'll wait for Mr. Stevens.
No eating on the job now. It's my lunch.
Where,
Okay, that's-
Judge Martin?
Call him, take him back on the bench.
Abraham.
Okay. We have both of Mr. Stevens's, we have Mr. Dubose for the writ, and then we have Mr. Atkinson for the plea.
All right, let's go ahead and do the plea.
Okay.
All right, okay, this is cause number CR 20147, State versus Eric Ephraim Atkinson. Before we go on the record, can someone go ahead and give me the terms of the plea?
I could do that, Your Honor. I've got
Go
it
ahead.
in front of me. Let me look quick. He's going to actually, Judge, it's a state jail plea, be a $2,500 fine. Looks like there's $290 in court cost, $180 in restitution. Looks like there's $35 reimbursement fee. And the proposed plea agreement is 6 months in a state jail facility. And I believe his back time credit, Your Honor, is 9 days.
And that's to PCS.
Yes, sir. It's a state jail PCS.
And this is an original plea. This is not an adjudication or revocation, correct?
No, sir. Straight new plea.
Okay. And so he's going to be pleading to what he was indicted with, correct?
Correct, Your Honor.
Okay, Mr. Atkinson, if you'll raise your right hand, I'll place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
No.
Say that again.
Yes.
All right, please put your hand down. And Mr. Atkinson, you are Eric Ephraim Atkinson, is that correct?
Yes, sir.
And Mr. Atkinson, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Bill Stevens. Are you pleased with his representation of you?
Yeah.
Do you feel like you've had enough time to discuss your case with him, have all of your legal questions answered?
Yes, sir.
Mr. Stevens, do you believe Mr. Atkinson to be competent today?
Yes, sir, I do.
You've explained to him his legal and constitutional rights.
Yes, sir, I have.
And Mr. Atkinson, you heard Mr. Stevens read the terms of the plea agreement to me. Is that your understanding of what you're going to be pleading to today?
Yes, sir.
All right, Mr. Atkinson, the charge of state jail felony possession of controlled substance and penalty group 1 less than 1 gram carries a range of punishment of not less than 6 months or more than 2 years confinement in the state jail division of TDC. Do you understand that?
Yes, sir.
All right. So, Mr. Atkinson, understanding that, how do you plead to the charge of possession of a controlled substance and penalty group 1 less than 1 gram?
Guilty.
And Mr. Atkinson, are you pleading guilty because in fact you are guilty and for no other reason?
Yes, sir.
Has anyone threatened you or forced you to make you feel like you had to plead guilty to this charge?
No.
All right. The court accepts the defendant's plea of guilt. Mr. Stevens, any objection to states 1?
No, sir, no objection.
All right. States 1's admitted into evidence and the court takes judicial notice of Mr. Atkinson's judicial confession. Is there anything further from the state other than a narration of the facts?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
Ms. Heisel, if you will, please, or Mr. Woodwhite.
Your Honor, it's mine. If I could have just a second to get into my notes here.
Yes, ma'am. Go ahead and do that. Mr. Stevens, before you turn that paperwork over, I'm going to ask that you make sure that everything is completely filled out. Specifically, look at the top, some of the handwritten styles of the case. You need to make sure we have the defendant's name, case number, court number, and just make sure the plea admonishments and everything is all completed correctly.
I'll do that.
Thank you. I appreciate it. Go ahead, Ms. Heisel.
Thank you, Your Honor. Your Honor, Mr. Atkinson is pulled over for speeding 66 in a 60-mile-an-hour zone, in addition to a couple of different technical violations on his vehicle. The officer notices he is acting very nervous. He says he is here doing work, but nothing about his dress or anything like that is consistent with the story that he's given the officer. So the officer asks for permission to search the vehicle, which Mr. Atkinson first agrees, then denies. They call out K9 Mito, who does make positive alert on the vehicle, and then they locate methamphetamine in the center console of that vehicle, Your Honor.
Mr. Stevens, any objection to that narration?
No.
All right. Based on the evidence presented to the court hereby follows the plea agreement, convicts Mr. Atkinson of this charge, assesses his punishment at 6 months confinement in the State Jail Division of TDC, assesses a $2,500 fine, $290 court cost, orders restitution of $180 and $35 reimbursement fee. Court awards Mr. Atkinson 9 days credit for time served in this case towards his sentence. Mr. Atkinson, hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you go with the bailiff to be fingerprinted, and then you'll be taken into custody at this time. Thank you, sir. All right, are we ready on Mr. Dubose?
Yes, sir.
Right.
Yes, Your Honor, I apologize for the delay. We're ready.
Okay, this is writs WR 21-16 and 17, Dakota Lynn Dubose seeking bail reduction. Is that correct, Mr. Stevens?
Yes, sir, it is.
Are you going to call your client today?
I am, Your Honor.
Mr. Dubose, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you may put your hand down. Go ahead, Mr. Stevens.
Thank you, Your Honor. Please state your name for the record.
My name is Dakota Lynn Bose.
And Dakota, how long have you currently been in jail?
Almost 2 months.
And you're being held on 2 different charges, is that correct?
Yes, sir.
Okay. And one of them is what we call a tampering with physical evidence.
Yes.
That carries a $10,000 bond. You obviously have not been able to post that bond.
Yes, sir.
The other charge is sexual assault of a child, 2nd-degree felony. That bond says $100,000, correct? Okay. Obviously, you're in jail. You haven't been able to make that bond either, correct?
Yes, sir.
Okay. Tell me, if the judge were to reduce the bonds, if you were able to get out, where would you live?
I'd be living residing with my mom.
Okay. Okay, and where would that be?
169 Private Road.
What? Grand Sling?
And I'm sorry, Mr. Stevens, when he turns to talk to you and you are conversational, Ms. Grisham's not able to, I can't hear it. She's not able to take it down. He needs to make sure either scoot closer to the television and microphone, or make sure you're talking towards the TV so that we can hear you.
Yes, sir. Thank you, Judge. So what I was asking, if you are able to get out of jail, where will you live?
In Grand Sling.
With who?
With my mother.
Would you have transportation to and from the courthouse or any other obligations the court puts on you?
Yes, sir.
Okay. And can you go to work? Yeah, you work, correct?
Yes, sir.
Okay. What kind of work do you do?
I was contracting framing houses.
If you get out on a reduced bail, is that a job you can go back to again?
My mom has me set up working sweeping at her job.
Okay. So you'll be able to go to work, correct?
Yes, sir.
Okay. You don't have any money in any banks, or you don't own any property you can sell, do you?
No, sir.
Okay. Now, if the judge reduce the bonds, how low do you think they'd have to get before you could make bond? For instance, the $100,000 bond, if that was reduced to say 20,000, and if the $10,000 bond was reduced to 5,000, are those amounts that you think your family could come up with to post the bond?
Yes, sir.
Okay. Are you asking the judge to reduce these bonds?
Yes, sir.
Are you promising the judge that if he does, that you will return and appear at court anytime you order to do so?
Yes, sir.
Pass the witness, Your Honor.
Mr. Stevens, you're requesting the 100,000 to be reduced to 20,000, and you're
Yes, sir.
the tampering or fabricating physical evidence to be to what?
To 5,000, Your Honor.
Okay. State, you have any cross-examination or questions for Mr. Dubose?
Very briefly, Your Honor. Mr. DuBose, you may have mentioned this with your attorney. How long have you been in jail, sir?
Going on 2 months.
Going on 2 months. What day were you arrested?
January 30th.
Okay. So by my calculation, that is 53 days today. Does that sound correct?
Yes, sir.
Okay. Mr. DuBose, do you have any property that you could sell? I think you spoke with your attorney about that. I didn't hear your answer.
No, sir.
Okay. Judge, I have no further questions.
All right, any further evidence, Mr.
No, Your Honor, would rest.
Anything from the state?
Judge, state would offer State's Exhibit 1, which is the affidavit for warrant of arrest and detention. If I would be allowed to share my screen, as I'm not sure exactly how to do that.
Has Mr. Stevens been provided that?
I have not seen it. No, sir, I have not seen it.
Okay, so before you offer, I'm going to allow you to share screen and then allow Mr. Stevens to review that. I'll tell you what I'm going to do. I'm going to put you in a breakout room real quick so that we're not streaming, and allow Mr. Stevens to review that since he hasn't seen it.
Yes, Judge.
All right, so give me just one moment.
Want me to show you how to share your screen? Also, I'm doing very
All right, Mr. Woodwide, Mr. Stevens, are we ready?
Yes, Your Honor.
All right, Mr. Stevens, have you had an opportunity to review? Oh, hang on. We got some technical issues over here. Just 1 second. All right, I'm sorry, Mr. Stevens. All right, have you had an opportunity to review States 1?
They're muted, Judge.
I'm muted?
No, jail court is muted.
I'm sorry.
All right. Yes, sir, Judge, we have reviewed it.
All right, do you have any objection to States 1?
No, Your Honor.
All right, States Exhibit 1 is admitted for the purposes of this hearing, and Mr. Woodwide, I believe you're enabled to share screen now. And I'll need you to provide that to the court.
Yes.
To Ms. Taberham by email.
Yes, Judge, I will do so. I will start here, Judge, whenever you want me to move it down, I'd be happy to.
Okay. All right, go ahead and move down.
Is that far enough, Judge? Too far? I can't.
No, that's fine. That's fine. Okay, I've reviewed it.
Judge, state has no additional evidence at this time.
Okay. Do you like closing argument, Mr. Stevens?
No, Your Honor. Well, briefly, we have a real young man here. He's going to be back with his family. He can go to work. So we're just asking to reduce the bond, let him get out of here, Judge, go to work.
All right, thank you, Mr. Stevens. Mr. Woodwide or Ms. Heisel?
Judge, based on the fact that Mr. Dubois has been in for less than 90 days, given the seriousness of these, the allegations against him, specifically in the sexual assault of a child case, state would oppose any reduction in bond. State would oppose the reduction on the tampering case solely on the grounds that it has not been 90 days. But we would ask that these bonds not be reduced.
Is Mr. Dubois also being held on a theft of property, $750 to $2,500?
Yes, sir. I think that is correct.
But that's not included in your writ today.
No, it's not. No, sir. No, sir.
Okay.
A writ just has the tampering and the sex assault.
Okay. All right. Court will take this under advisement and will issue a written ruling in an order at the conclusion of our docket today, and I'll provide that to the state and to you, Mr. Stevens, by email.
Thank you.
Thank you, Your Honor.
You're welcome.
All right. Well, here, I will let you know.
Sure. We're right down there. He's got 2 more courthouse.
Mr. Stevens,
Yes, yes, sir. Yes, sir.
would you mind coming to the courthouse and meeting with the other 2 clients?
I'll be on my way in about 5 minutes, Judge.
Yes, sir. Thank you. I appreciate it.
Yes, sir.
Judge, I'm sorry, did you want that affidavit sent to Ms. Taberham or to Ms. Barker?
Send him for him.
Yes, Judge.
Right, we will come back to the courthouse.
Okay. All right. You can close down that session there. And the state will just stay on this Zoom ID and resume when Mr. Stevens gets to the courthouse.
Yes, Judge.
All right. Thanks.
Whichever one I do, different.
Oh, let's see here. Who got here first this morning? Mr. Williams, step on up. All right, let's give the state of Texas a moment, see if they are gonna.
Here, Judge.
I believe we're both here, Judge.
All right, this is cause number CR 2372, State versus Leonard Marshall Williams. And we are set for pretrial today, Mr. Stevens.
Yes, Judge, I want to ask for another pre-trial, to be honest with you. Today was the first time that my client and I really got together on the case. We visited on the phone in person. He's giving me some information I need to check out for place. I'm going to ask for another pre-trial.
How long have you had the discovery and things?
I couldn't tell you offhand. I don't know.
State, what's your position? Today was the deadline for Mr. Stevens to. And Mr. Stevens, can you slide over this way?
Yes, sir.
Maybe we move that thing again, but I want you, there you go, that way. Here, come on over this way. Come on over this way. Keep on going, keep on going. There we go. Keep on going, a little more. I thought we had it set up over here. There you go.
Okay.
Okay, that way the prosecutors can see you and Mr. Williams. Stay, do you have a position on Mr. Stevens' request?
Judge, I show that the discovery was sent to the portal February 23rd, so almost exactly a month ago. Again, I don't know what time Mr. Stevens actually accessed that or gained access to it, but it was sent to his portal a month ago. I couldn't quite hear what his request was other than for a reset for additional pretrial, but I couldn't hear the reasoning.
He said this was the first day that he's met with his client to really get together to go over things. And so he was asking for more time to just another pretrial setting.
That's correct.
And so my question to you was, today was the deadline, statutory deadline for him to file pretrial motions. You'll have any objection to an additional pretrial?
Judge, I don't have an objection to Mr. Stevens's request for additional pretrial. Mr. Stevens is usually on top of such things. I have no doubt that he will efficiently take care of business.
All right, are you available on April 27th, Mr. Stevens?
Yes, sir.
All right, the court will set Mr. Williams in for an additional pretrial on April 27th at 9 a.m. So Mr. Williams, you'll appear in person on April 27th with Mr. Stevens. Mr. Stevens is going to fill out an appearance form. It's going to have that date on it. Once you get the yellow copy, you're free to go. Do you need? Once you get that yellow copy, come over here and see Ms. Burns with the probation department, pretrial release, and she'll have additional information for you, okay? And then once she's through with you, you'll be free to go. All right. That's okay. All right, Ms. Gibson. All right, CR 2249, State versus Leslie Denise Gibson, and we're set for docket call today.
Yes, sir, we are. I visited with my client, Your Honor, and I'm going to ask for a little more docket call. The reason being is I got some information I want to discuss with the state about her case, which might be helpful in resolving the case. Basically, she's making a counteroffer, so to speak.
Judge, I can't understand Mr. Stevens very well.
I'm asking for another docket call. I'm visiting with my client, and I want to get with you probably one day next week and see if we can resolve this. So I was asking for another docket call.
State, do you have any objection?
Judge, I think the state's going to take no position. I don't think we will oppose, but we've been on docket call for 3 months at the court's pleasure.
Well, I was looking at her case. It looks like this is just our second docket call. Our first was in February.
Okay, in that case, state has no objection, Your Honor. Again, I have no doubt Mr. Stevens is taking care of business, and we shall work towards some resolution quickly.
I'm gonna try to get with you either later this week or next week. Maybe we can resolve this.
All right, Ms. Gibson, I'm going to set you for an additional docket call on April 27th. But if I drug test you today, are you gonna be clean? Sure. All right, so I'm gonna do that. I'm gonna go ahead and UA you today. I did that to a couple of individuals earlier, so I want to be consistent. Do you have UA? So once you get that yellow copy, come over here and see Ms. Burns. And State, if you'll just stay with me for a few minutes.
Yes, Judge, we'll be here.
While we're waiting on Ms. Gibson, bailiff, can we call Carl Klump loudly and distinctly 3 times in the courthouse? Carl Gene Klump.
Carl Gene Klump. That's only one.
That's the only one. All right, the court has called CR 2294, State versus Carl Gene Klump. And court has also called CR 297, State versus Robert Brandon Yates. Neither of these individuals appeared at any time in this court this day. Court finds that both Mr. Klump and Mr. Yates have received notice of today's hearing. Court is going to issue a judgment nisi for Carl Gene Klump. His name was called loudly and distinctly 3 times in the courthouse with no response. With regard to Mr. Yates, counsel, Mr. Ashmore indicated that Mr. Yates was hospitalized and that he would be attempting to get information from the hospital to support that. So the court is going to take a judgment nisi under advisement until 5 p.m. tomorrow. And Mr. Yates' name was called loudly, distinctly 3 times in the courthouse with no response. And he also received notice of today's hearing. So we're going to stand in recess for just a moment. State, are you ready?
Yes, Your Honor.
All right, court recalls CR 2249, State versus Leslie Denise Gibson. The court has set Ms. Gibson for docket call on April 27th, and the court has had the pretrial release officers administer a urinalysis test. Ms. Burns, do we have an update on that for the court?
I did before administering the test. I asked her if she had used, and she said that she had used methamphetamine yesterday on March 22nd, 2021. She's not in UA caution.
Mr. Stevens, do you have any, if you'll move over here, let Mr. Stevens get in there, Ms. Burns, and then Mr. Stevens, do you have any questions of Ms. Burns?
No, I don't.
Okay. All right, so is there a compelling reason why the court should not take Ms. Gibson into custody for violating your conditions of pretrial release?
May I visit with her for just one moment?
Yes, ma'am. Yes, sir.
Asking if you would let her go, that she promised that she would test negative next time, and she's willing to take weekly drug tests or anything required.
Unfortunately, I'm going to deny that request, Mr. Stevens. I feel like I have to be consistent and fair in the way that I administer the court. And this morning, 2 individuals also took drug tests. One was positive and one was negative. And so the one that was positive went into custody. So this time, Ms. Gibson, I'm going to find that you have violated your conditions of pretrial release. Court's going to find your $10,000 bail to be insufficient at this time. Court's going to set new bail in the amount of $50,000 and take you into custody at this time. You are. And so we're going to take Ms. Gibson into custody.
Yes, sir.
All right, court is now going to be, I believe that we have taken everything up. So court's going to be adjourned at this time. State, do you see that I've missed anyone on the docket that you're aware of?
That appears to be everyone to the state judge.
All right, so court will be adjourned. Thank you, Mr. Woodwike.
Yes, Your Honor.